Sathiyo, today we will discuss the concept of a state as enshrined in the Indian Constitution. But the problem is that in the Indian Constitution, the state has been used in more than one sense. For example, I will give you an example of two articles, Article 1 and Article 12. In Article 1, it says India, that is Bharat, shall be a union of states. Union of states. So here you find state, represented as a plurality. There are so many states, and obviously the reference here is to the several federating units. That means the several provincial units. At the time of making the constitution, there were hundreds of deshi riyasates or princely states, which you used to call. So they are also included in this term states, and also the British provinces, which were also included in the term states. So states in Article 1 has been used in a pluralistic sense. Whereas in Article 12, which is the first article in the chapter on fundamental rights, the state has been defined. That what is the state and why it has been defined, because the state has the responsibility or onus of defending and protecting the fundamental rights guaranteed by the constitution. Not only that, the state here in Article 12 has also a reference to all the directives which are given to the state, that means the Union of India, in chapter 4 of the Constitution on directive principles. So as we can say that what the Constitution tries to do in Article 12 is that in using the word state here and defining the word state has been defined especially in the context of chapter 3 and chapter 4. That means a chapter on fundamental rights and chapter on the directive principles of state policy, which clearly state that the state is barred from taking away the fundamental rights of the citizens, or it has the onus and responsibility of protecting fundamental right. And should there be any violation, of course the citizen has been provided in the constitution some guarantees. Under Article 32 of the Constitution, the citizens can move to the Supreme Court directly for the protection of their fundamental rights. Now, so coming back to Article 12, that in Article 12, a very interesting, phraseology has been used by the makers of the Constitution, which says, and you should note it very carefully, that Article 12 says, in this part, unless the context otherwise requires, the state includes the government and Parliament of India, the government and legislature of each of the states, all local and other authorities within the territory of India, or also under the control of the government of India. So here you can very clearly see that the state is again being defined in both the unitary sense and the pluralistic sense. In the unitary sense, it is making a reference to the union of states, that is Article 1. Whereas in this Article 12, the state is being defined for not only the union but also the federating units of the union and several other authorities which are there or which are under the control of the government of India, or several governments. So state, and you will realize that state has been differently defined if the context so warrants. That means the definition of state in Article 12 pertains probably only to the fundamental rights and the directive principles, whereas there is a disclaimer in this article which says that unless the context otherwise requires. That means state can be interpreted differently if the context so warrant. But so far as Article 12 and Article 12 is concerned, the concept of state, the definition of state is applicable to the chapters on fundamental rights and the directive principles, because the state has the onus of protecting fundamental rights and state has the onus of implementing the directive principles of state policy, of which the latest is, as you can say, the Common Civil Code, which is also sanctioned by the chapter on directive principles of state policy. And obviously, these days there is a discourse that if the country is one, if the family is one, if the society is one, of course, with certain differences and pluralities, but there should be a common civil code at least. So that is at the moment that sometimes else when we discuss. Now, Dr. Ambedkar, was asked why this definition has been put in the chapter on fundamental rights. Why state is being defined with reference to fundamental rights, and what is the reason that the scope, what is the reason of putting a phrase called other authorities? So here is a confusion, because there is no confusion about the government, union government and parliament and so on. There is no confusion about the governments and legislatures in the state. There is no confusion about the local authorities, which are also now part of the constitutional scheme after the 73rd and 74th amendment. But certainly the other authorities remains undefined in the constitution, and therefore the judiciary has tried to time and again define what is this other authorities. And obviously they all, whatever is given in the constitution, and whosoever is the authority has a certain power, certain authorities. And these authorities, they obviously include the central government, provincial government, government of Indian state, because at the time of making the constitution we were also making reference to the princely states, and all the local government, which at that point of time were subordinate to the state governments, but now they are an independent constitutional bodies. Now these questions have been repeatedly being raised, that besides the union government, state government, and the local government, the other authorities, what are they and who are they? And from again and again, this has been a matter of litigation and so on. The first very important case came in the case of University of Madras versus Shantabai case, and was decided by the Madras High Court. And in this judgment, the Madras High Court ruled that only those institutions which were performing, duties of the nature of sovereign bodies, or they were involved in functions similar to the one which are performed by the governing institutions of central and state or local bodies. And therefore the Madras High Court propounded a principle called adjus dem generis. That means, it means things of like nature. That means all those bodies who are performing functions akin to the union government or state government or local government, only such bodies will be considered to be come within the purview of other authorities. However, this decision of Madras High Court was rejected by the Supreme Court in a case called Ujjam versus State of UP. And in this, the High Court said that no, this principle cannot be accepted, because all these institutions, union government, state government, and local government, there is no common generic component of function and authority and so on, and so therefore this cannot be accepted. So they rejected this, and finally in the Rajasthan Electricity Board versus Mohanlal case, the Supreme Court said that even those institutions which are not performing governing functions, or which are not performing functions of the nature of sovereign, and performing many activities which are likely to intrude on fundamental rights, they can also be considered to be institutions within the framework of, within the ambit of other authorities. So the Supreme Court finally propounded a criteria that in addition to the union government, state government, and the local governments coming within the ambit of other authorities and other authorities, the other authorities which would be considered to be a component of the state or part of the state should be such authority which are financially, functionally, and administratively dominated or controlled by the government. So if you find any body, any authority which is set up under the law and exercising jurisdiction and power and authority, and this body is funded or controlled by financially, functionally, administratively by the central or state government or local government, then this body will come within the ambit of other authorities. So this was the clarification finally given by the Supreme Court, and thereafter, as you can see, since the era of LPG, liberalization, privatization, and globalization, we find that many private players have been overtaking the activities of the state because there is a lot of privatization. So when you have privatization, you find that a lot of the functions of the governments, they are transferred to the private players, and in the process, the private players start, the private enterprises, they private parties, they start exercising many functions which were earlier exercised by the state government or the central government or the local government, and therefore earlier you could go to the Supreme Court directly or High Court for the enforcement of your fundamental rights, and therefore the Supreme Court said that now since those functions are being performed by even private players, therefore such private players performing functions controlled by, dominated by, and funded by the governments, they would also, and they might impinge upon the fundamental rights of the citizens or subjects, and they are within the ambit of the other authorities, and thus the Supreme Court has brought in ONGC, LIC, Income Tax Department, and several other, such bodies within the ambit of the. He said they would come within the ambit of the other authorities against whom a writ jurisdiction lies. Now, a very important and interesting part of the entire discussion is whether the judiciary is a component of the state or not. This is a very tricky thing because right from our childhood, we have been listening, we have been hearing, we have been learning that government has three parts: legislature, executive, and judiciary. I mean, there is no disagreement on this. And because government is an agency or a concrete manifestation of the abstract entity called a state, therefore the judiciary inevitably becomes a part of the government. So if judiciary is one component of the government and government is an agency of the state, consequentially and conceptually we find that judiciary should be a part of the state for sure. But the problem is that Article 12 does not mention judiciary specifically, and therefore it mentions union government, and as we have already seen, legislature and executive of the union government, legislature and executive it could have also said judiciary, but no, it did not say. Article 12 is silent on that point, and therefore the question is that the other authorities which the Article 12 makes a reference to, can judiciary be included in that other authorities, and can it come within the expression of other authorities within the territory of India? This is a subject of discussion in the judicial fraternity and otherwise also, because the judiciary was set up under law. Judiciary has been set up under law, and judiciary exercises judicial authority. So it is exercising an authority and it is making rules. The Supreme Court judgments are virtually their dictates. They are binding on the entire country. Therefore, the Supreme Court keeps on making new laws and new rules by way of interpretation and so on. And not only that, it is possible that in so doing, the Supreme Court may discriminate, and therefore Article 14 may be attracted so far as the individual is concerned, so far the citizen is concerned, so far the people are concerned. Some legal experts, they are of the view that the Supreme Court has the power to make rules, and Supreme Court has also the power to appoint its staff and decide its service condition. However, in nutshell, just to wind up and be brief, we have seen that most of the judicial fraternity and the Supreme Court included, they have tried to concede some space on this, but they have tried to create some distinctions also between the judicial functions and the non-judicial functions of the court, between the exercise of judicial authority and non-judicial authority. Now, the court thinks that, and many jurists also think that, the while performing the judicial functions, the court is not a part of the state because it has not been expressly mentioned in the Article 12 of the Constitution. But so far, exercising the non judicial functions are concerned, as we have just mentioned, like Supreme Court has administrative functions also. So, while exercising the administrative functions or non-judicial functions, the Supreme Court can certainly be said to be within the ambit of the other authorities mentioned in the Article 12 defining the state. So, the judicial decisions of the court, they become the non-state functions, and since they become the state, it doesn't come within the ambit of a state, therefore you cannot go and file a writ petition against the judgments of the Supreme Court and the High Court saying that the judiciary has impinged upon my fundamental rights. So that's very clear that the judgments of the Supreme Court in no way are violative of our fundamental rights. They are rather, they are protecting your fundamental rights. So the court would not concede on that. It would not consider that the judiciary is a part of the state. And secondly, while performing non-judicial functions, of course, they consider that they can be considered as state, and if some administrative miscarriage has been done, or somebody feels offended about that his her fundamental right has been impinged upon by the administrative judgments of the administrative actions of the courts, then a judiciary, it can, or he can move to the Supreme Court for the enforcement of that fundamental right. Mr. H.M. Sherwai, a very eminent jurist and constitutional expert, has opined, and it's worthy of consideration, that he says that it can be right and wrong, it can be debated, but he has said that judiciary should be included in the definition of the state. A very, very categorical statement. And he also said that a judge acting as a judge is subject to the writ jurisdiction of the Supreme Court. That's his personal opinion, but the court has not, been able to accept that opinion. But however, we have tried to discuss Article 12 and how Article 12 has treated the concept of a state in the Indian Constitution. Of course, whether judiciary is within the ambit of that state under Article 12 remains still elusive and undecided, because the court would not agree to that, and the court would only partly concede that judiciary, to the extent it is performing administrative functions, could be considered to be a part of the state. But so far as the non-judicial functions, judicial functions of the court are concerned, judiciary would extricate itself from the ambit of state. Thank you very much.